This is case number 21-17-1768. This is Auto Club Group versus Deandra. Matter set before the court for hearing. Your appearance at this time for the plaintiff, please.
Yes, good morning, Your Honor. Dylan White, P80755 for Plaintiff Auto Club Group.
Thank you, Mr. White, and good morning to you. I'm looking now for defendant in this matter. Looks like that's Deandra Fields. I also have Cedric Fields regarding this matter. Let me know if you're here, Fields. Identify yourself at this time.
We're all here. Good morning, Your Honor.
Good morning, Your Honor.
I'm Dina Lucas.
Thank you, Ms. Lucas. And who else do I
I'm
have?
Cedric. And I'm Cedric Fields.
Thank you, Mr. Fields. And who else do I have?
And Deandra Fields.
And Deandra Fields. Thank you. Good morning to each of you. There was a default request with regard to each of these matters. Counsel, go ahead and update me regarding this matter, sir.
So it looks like last week, all the parties met and we were looking for a proper answer to be filed by the defendants, which it doesn't appear that they did. They may have filed something that was more narrative in form in the beginning of June, but you instructed them to file a count by count answer, which we have not received in the week since you instructed them.
Right. I see my notation where a defendant must file and serve an answer by 6/7/22, and then I set the pretrial in this matter. So what happened? I don't see any document that is populated to the file as relates to either defendant indicating a point-by-point answer to the complaint.
Your Honor, we sent it through email to April Wright. And we also sent it to a Denise Baker
At the Velo Law.
at the Velo Law.
Counsel, do you have any, you know who those persons are, counsel?
I do know who Denise Baker is, but it doesn't look like she has uploaded anything other than
I need to look at them. I need to look at their email.
it looks like a correspondence that was from June 1st, 2022, date stamped by the 36th District Court, but we haven't received anything other than that.
Let me, just one moment, I'm checking register of action.
Your Honor, this is the email for the Velo Law.
Don't show that to me.
Today, she put it in today.
It's me looking at a cell phone over the system, that's not gonna work. All right, what I have a notation on the register of action indicating that. See what I can do.
Today. I don't know why she didn't bring it up there. Let me go. Let me call her.
I have a notation that an answer has been filed as of 7/5. That's when it was put in the system. So it was put in the system today. It has not populated to my file. The crucial issue here is whether or not the answer, who it applies to, number one. I know that there are 3 defendants, and secondly, whether or not it comports with the court rules. The court rules require that an answer be with particularity as relates to the various allegations raised in the complaint. So what I'm going to do is I'm going to set this matter over for until Thursday. And I'll take another look at it Thursday. I should have the document by that time. And Mr. White, you'll be able to find out whatever correspondence you may have received. I want to take a look at it and see what the answer looks like in this matter. I'm going to go ahead and set it on a crowded docket on Thursday. That's going to be at 10:00 a.m. Thursday at 10:00 a.m. You'll need to be back on the Zoom at that time. That's this Thursday, the 7th of July at 10:00 a.m.
10 a.m.
All right, I'll see you guys at that time. All right, good day to you.
We'll see you then.
Your Honor.
The court now looks at case number 22-17 8921. This is Madison Heights Imaging Center, doing business as Michigan Diagnostic Center Incorporated versus City of Detroit. Your appearance at this time, your appearance at this time for the plaintiff. Do I have plaintiff on this Zoom for Madison Heights, City of Detroit regarding this matter?
Yes, Patricia Porter for the City of Detroit, P66989.
Thank you, Ms. Porter. Good morning to you, Ms. Ms. Porter. What has happened here? Have you spoken with anybody on the other side of this? I know I said it over on the previous day.
No, I did not speak with anyone. I just anticipated they would show and maybe we would get a scheduling order.
Right. All right. I do see, of course, they've filed appropriate documents to see the plaintiff's initial disclosures. Well, I'll go ahead. I think the better course here is perhaps go ahead and set a scheduling order regarding this matter. So I'll go ahead and set it up for 60 days of discovery with a pretrial date set thereafter. I'll allow for open discovery during that period of time up and through the pretrial conference date. I'm going to give you that date in just a moment. My standing order will apply as well. That if there are any motions that either side wishes to file, dispositive or non-dispositive, such motions can be filed so long as notice is given at least 10 days before the hearing date to the other side, to the person opposing the motion. I'll hear it on the next action date. That pretrial conference date is going to be
On September 12th.
September 12th, 2022, and that's going to be at 9:30 a.m. That's 9/12/2022, 9:30 a.m. An order will be generated today and sent to you, Ms. Porter, as well as to the other side regarding this matter. See you at the next time.
Okay, thank you very much.
Thank you, Council. Good day to you.
Good day.
Court now calls case number 17-105-077. This is Department Stores National Bank versus Shana Dorsey. The matter is before the court. Looks like there was the filing of a motion for satisfaction of judgment. The court took the motion under advisement and sent it on for hearing on today's date. For the plaintiff in this matter, your appearance at this time.
Yes. Oh,
For
I'm
the
sorry.
plaintiff, for the plaintiff department store. Anyone
Your
else
Honor,
or-
Your Honor, that's usually a client of ours. This is Joseph Schmon here on a Citibank matter. I'm not sure if we received or didn't receive a notice of appearance, but do you show Stenger and Stenger as the attorney of record?
I do not. It looks like I show an Eduardo Polaris in Auburn Hills.
Okay, that would be a different firm, so that wouldn't be one of ours. Thank you, Judge.
All right, thank you, counsel. All right, now, do I have Shana Dorsey on this Zoom?
Yes, you do.
All right, thank you, Ms. Dorsey. Good morning to you, ma'am.
Good morning.
All right, so you filed the motion to or satisfaction of judgment. Tell me why you think the judgment should be satisfied at this time.
The reason why I think it should be satisfied is because when I attended court in 2017, it was an agreement made with me and the representative of the law firm where I agreed to pay half of what I owe, which was $2,400. I paid that, and then here it is, 6 months later, I get a letter from another attorney group saying that I owe them $1,200. So I don't know what went wrong where it was not recorded that I did pay the half. I sent it to the attorney office that's trying to garnish me or sue me for the difference.
All right, when did you get some information from someone trying to sue you for the difference? How long ago did someone reach out or contact you now?
That's been every bit about 9 months ago. I had to go to the bank. I had to get my bank statements to show proof. I did that. Then I waited like a couple months for them to investigate that. They did that portion, and then they finally just came up with a decision that what they discovered and what I turned into them, they couldn't accept. So I immediately started doing my own investigation. I tried to contact the company that took me to court on behalf of Macy's and they just, I don't know, they like vanished. I don't know.
All right, so do you have, when you entered into the agreement with an attorney back, I believe that was in 2017, is that correct, ma'am?
Correct. Hmm.
Did you, do you have any document that you signed in that regard?
And I do not. That's the part that I don't have. And from what I was told was the company, once I paid that half, they were supposed to send me a letter of satisfaction. And I didn't get that. I don't know if I didn't get that because they went out of business or what. I don't know why.
So you did, and that was not included on the judgment, correct?
It was not. It was not. Nope.
All right. And yeah, that's fundamentally what the problem is here. I do see the judgment entered in 2017 for $2,538.28. That was the judgment amount that was entered. You indicated that that the agreement was that you would pay half of that and then they would give you a satisfaction. I don't have anything showing that. Of course, you don't have anything to show that, and that's why it seems that they're coming after you. I don't know why they're not here today. I did send a notice to the attorney in Auburn Hills. Is that the attorney that's been trying to reach out to you, Eduardo Ferraris? Is that who you've been
No.
dealing with?
No, this is a totally different company that's coming after me that took over the account for these people. I tried to reach the people that's on the judgment and they're out of business. They're no longer in business because I tried to resolve it through them first before I even came down to 36th District Court.
Yeah, I got you. All right, so you, when is the last time you paid money on this? When did you finish paying off this?
I finished paying them in August of 2017.
And when is the next time that you heard anything about someone trying to collect against you?
I got a letter from a lawyer, maybe like October of 2021.
All right, so 5 years later, correct, or so?
Yeah. Uh-huh.
All right, I'm going to grant your petition at this time, ma'am. It seems that such a delay of 4 or 5 years before attempting any collection action would suggest that the payment that you made was deemed to be a payment in satisfaction of the judgment. The fact that 4 years later or more than 4 years later that someone else would reach out to you and say that you owe money without there being any intervening issues is of great concern to me. So my determination is that that the judgment has been paid, that there was an agreement to compromise on the judgment, and that you satisfy that condition. Accordingly, the court will issue an order indicating that the judgment has been satisfied. Now, I'll send a copy of that to you in the mail in the next few days, ma'am. Good day to you.
Thank you. I appreciate that.
Have a good day.
You too.
All right, the court now looks to 22-177-356. This is Georgetown Village 2 owners, owner B LLC versus Charles Murray. The matter is before the court, set on for a hearing. Looks like an answer, something reported as an answer to filed in this matter. Your appearance for Georgetown, please.
Good morning, Your Honor. Sandra Francis on behalf of the plaintiff P74229.
All right, thank you, counsel. Good morning to you, ma'am. I'm looking now for Charles Murray on Cherry Lawn Street. If you're on the Zoom, say something at this time. Charles Murray. The matter set off at 9:45 a.m. It's now 10:19. I'm looking for Mr. Charles Murray on Cherry Lawn Street in the city of Detroit. If you're on the Zoom, please say something at this time. All right, this is the date and time set for, I think the first hearing regarding this matter does appear that it was personally served with the complaint in this matter. It also appears that the court provided a notice dated April the 26th, indicating that the hearing would take place on today's date. Counsel, have you had any contact with Mr. Murray, any discussions along the way? regarding this matter?
Your Honor, we have not, and we have not received a copy of the defendant's answer as well. So I was going to request if the court is able to provide us with a copy of the answer, but we've had no communication with her.
All right, and what I've loosely referred to as an answer is better summed up as a response, and that triggered the court setting it for a status conference. It basically said, my name is Charles Murray. I'm writing on behalf of the summons packet I received approximately 2 weeks ago about a collection of a residence I previously lived at. I was instructed by property management not to pay the past due rent due to an intention to evict conversation that was held in the front office of the property. Now I'm receiving a bill saying that a collection agency is attempting to sue to collect the previous bill I was instructed not to pay by the property management. I believe I received the summons in error, not working. So in order to pay, I would need to find employment. I can be contacted, and it needs a number. That's not really an answer, but again, I said, as I indicated, that was a response to trigger hearing date. Nonetheless, the defendant is not here for the hearing. We have no calls or anything indicating that he wished to be here, or that he has connection problems or anything. So the court at this point would have to find that the defendant is in default. And on the expiration, the court will enter default on today's date. On the expiration of 14 days, the court will enter judgment by default.
Your Honor, did you want us?
I'm sorry, Madam Counsel.
I'm sorry, Judge. Did you want us to submit that under the 7-day rule, or we can just mail it to the court?
You can submit it to the court for entry after the expiration of 14 days.
Okay. And Judge, is it possible we can get a copy of that answer just for our records?
Yeah, that would be good. If you chat me your email address, I'll have my clerk to email it to you.
Okay. Thank you, Judge.
Thank you, Counsel. Good day. The court now calls case number 22-182-827. This is Latera Reed, it appears, versus Ben Bantel, AD Motors Auto Sales. The matter is before the court, set on for a status conference, scheduling conference. Your appearance at this time for the do I have the plaintiff or any attorney for the plaintiff say something at this time? Reed, or any attorney for Ms. Reed? Do I have last name Reed, living on Chesterfield Street? If you're on the Zoom, please say something at this time. All right, let me have counsel for Ben Bantel or AD Motors Auto Sales. Your appearance at this time, please.
Yes, good morning, Your Honor. For the record, John Ali, P number 37913, appearing on behalf of the defendants.
Thank you, Mr. Ali. Good morning to you, sir. It looks like the defendant is not, the plaintiff does not appear regarding this matter. Record should reflect that the complaint was filed this matter in March of this year, March 29th. It appears that upon service of the matter, the court did in fact set it on for hearing on today's date. That notice went out on the 26th of April, indicating that today's date would be the date of hearing. Time was set at 10 o'clock a.m. It's now 10:24 a.m. I've not heard anything from one Ms. Reed on Chesterfield Street. She's not called the court, indicated any connection problems at this time. Counsel, have you had any dealings with Ms. Reed? Any discussions, negotiations, or anything up to this time, sir?
She did call me one time and indicated my client did repair work and gave a 90-day warranty. And otherwise, the vehicle that they sold her was as is, where is, which is usually the only way my client sells vehicles. And they were trying to help her out. So they gave her a 90-day warranty. She didn't take her car in until well past the warranty expiration date. And so that was essentially our defense. So she just called and, very polite. I'm a single mom. I have a child. And, I mean, I felt bad. I don't think she can sustain her claim legally. And that was it. We just had one conversation and that was really it. She did claim that she thought that my client waited to do repairs till after the warranty expired, but my client said that wasn't true. So that's all I have, Your Honor.
And you didn't tell her that she shouldn't appear at this hearing or anything along that line?
Well, I mean, I didn't talk to her about this hearing, no, Judge.
All right, it appears then that the plaintiff has not appeared for this matter. And again, the court did send out the appropriate notice. And for that reason, the complaint in this matter will be dismissed where the plaintiff has not appeared as directed to do so by the court. So I'm going to sign a dismissal today, and that will be circulated via mail.
All right, very good. Thank you, Your Honor.
Thank you, Mr.
Oh,
Howard.
okay. All right, bye.
This is case number 22181426. This is Citibank versus Benoit Hicks. The matter is before the court, set on for a hearing on today's date. Your appearance for Citibank, please.
Yes, good morning, Your Honor. Joseph Jamal on behalf of Citibank, P71254.
All right, thank you. Thank you, Counsel. Good morning to you, sir. I'm looking for last name Hicks. Last name Hicks, if you're on the Zoom, please say something at this time.
Yes, I can't see you, but I'm on there.
All right, thank you. What's your name? Mr. Hicks, are you there?
Yes, I'm here.
All right, what is your name?
Benoit Hicks.
All right, thank you, Mr. Hicks. All right, got you, sir. And again, good morning to you. This case arises by virtue of the plaintiff, they're suing you, indicating that that you owe a debt arising out of the use of a business card or a credit card. And they're alleging that the amount that is owed regarding this, just one moment, let's see what we got here. Is $2,224.80. Anything you wanted to say about that, sir?
Yeah, I keep telling the children that I did not charge that stuff. All that stuff somebody else charged, but I don't know who. I haven't charged nothing on that account. I did nothing to that account. 9/4/2018. I turned that over to Freedom Debt Collector.
Okay, I can already hear you now.
They didn't pick it up because somebody paid on it.
Okay, let me ask you, let me stop you for a moment. Whatever device you're on, perhaps you need to turn the volume up because I can hardly hear you. I mean, it's clear, but I can't hear you. It's so low. You're either far away from it or you need to turn it up a little bit so I can hear you better. Go ahead, Mr. Hicks.
God, can you hear me any better?
Yeah, I hear you a little better. Stay close to your device because your voice is not as strong as some. So you said now, did you have a Best Buy card?
Yeah. I called them when I found out that they didn't pick this bill up, so somebody had paid on it. It was a year or so later. I thought the thing was paid off. And then I've been talking to them ever since. And when they sent me the paper where the guy had charged or whoever it was and what he had paid on it, all that was in the 1900s. And I quit paying on this thing, quit charging on it, quit doing anything on it about 2 months before the 9th and the 4th of 2018. That's when I turned it over to the debt collector. Then when I first called them, they couldn't even find the bill with my phone number. They said, well, you lost your card. They said, no, I ain't lost my card. I still got my card. And then after next time I called to check with, they didn't have no trouble. They didn't got it all put on my card. So I don't know what card the other guy was using. I know that somebody that charged all this stuff. I ain't had nothing to do with it.
All right, so did you have other people that you allowed to make use of your card?
No, I ain't gave this card to nobody.
All right, but you did buy some stuff on it, right?
I bought some stuff on it, yeah. Back in the
All right, let me hear.
1800s.
Okay, let me hear from the other side. Council, what's going on here? Obviously, I received a response, not necessarily an answer, but we treated it as such for purposes of setting this hearing. Mr. Hicks, in that letter, talks about their charges made in Tennessee. I live in Michigan for a computer and other items that I never bought or purchased. These were fraudulent charges made to my account. Payment history will show that all of my payments were made from Michigan and that they were all on time. It says I'm willing to pay $272 of the accumulated debt. That is what I feel I'm responsible for. Did you receive that document, Council?
We did, yes, Judge.
Tell me what your thoughts are about this matter, if you will, sir.
Yeah, so looks like we received some disputes from the defendant prior to even the case being filed. We sent those disputes to our client for review. We also sent out some documentation to the defendant, which included the statements and the charges made, which I think is where he's probably able to reference those specific statements when looking through. Our client indicated that they did not show that any fraud occurred. I don't necessarily know the details of, if these were online purchases or phone purchases that were made, and thus they show Dallas, Texas, or Tennessee. But I do think that might be something through discovery that I can dig into a little bit deeper if we can have some time to look into those details a little bit more.
All right, so Mr. Hicks, there, of course, there is a dispute regarding what occurred here, and so the next step in this case is to allow for the respective parties to research the matter through a process called discovery. So I'm going to grant a period of discovery where, as you've done in the past, and if you need to do now, you can ask the other side in writing for any documents that may pertain to this case. And they can ask you for any documents that you may have or ask questions of you regarding this case, and you can do the same mutually. That's going to occur over the next 60 days. I'll allow either side to research, ask questions, serve documents called requests to admit, or anything along those lines to try and get to the bottom. And then I will conduct a new pretrial conference on the date that I'm going to give you. That date is going to be September 12th, 9/12/22 is the next time that you're coming back. It'll be at 9:45. That's 9/12/22 at 9:45 a.m. Discovery will be open through that date. Both parties can exchange information, can ask questions, can serve requests to admit, and can request any documents that may pertain to this matter. And then at the conclusion, I will review this matter on the 12th of September 2022 at 9:45 a.m. A notice will be generated, and each side will know to come back on that date. There's also a provision that will be in an order that I'm going to send out that allows either party to file a motion or a petition with the court and have it heard on the 12th of September. If you wish to file a motion dispositive or otherwise, you can do so, and I will hear it on the 12th of September, so long as you filed it early enough for the other side to have at least 10 days to respond. So all you need to do is allow 10 days to respond, and I will hear the motion on 9/12/22 at 9:45 a.m. So you'll get documents in the mail regarding this matter in the next few days. I do wish both sides well, and good day to you. See you on the 12th of September.
Yeah, now what, I don't understand what you just, I don't know how to research nothing. What I'm supposed to do?
What you're supposed to do is you'll get a document from me in the mail in the next couple of days that's going to tell you that you have the right to discovery. That means to request documents, request information from the people that are suing you, and they have the right to do the same thing with you over the next 60 days. At the end of that period, you come back to court. That the date is going to be in the document, and you'll be able to come in front of me and file any motions or make any petitions or requests that you wish to make in front of the court on that date. You understand?
Okay.
All right. I wish you well. You'll get the document in the mail from me in the next few days. Good day to you, sir.
Thank you all.
Thank you. All right.
Yeah.
All right. I've called all the cases that I have today. I see two people that are on here. Tell me who you are and why you're here. Can't hear you, ma'am. You'd have to unmute your device, which is *6. *6 on your device will help you to unmute yourself.
Oh, hi, Your Honor. Good morning.
Morning.
My
Morning,
name is
ma'am.
Latyra. My name is Latyra Reed, and I had a meeting today at 10 because I was suing A&B Motors, but they gave me the wrong information.
Well, you got a notice from me regarding this court date, and so your case came up, and the case was dismissed because you weren't here.
Oh my!
Why didn't you zoom in earlier than now, ma'am?
So was nothing I could do?
Did you hear my question? Why didn't you zoom in to me earlier? Why?
Because I'm sorry, Your Honor, they gave me the wrong Zoom information. I moved out of that place, so all my stuff is in storage. And when I talked to the young lady on Thursday, she gave me the wrong Zoom information. So when I finally got into court, he gave me the number to call, and then they gave me this number.
Well, I sent you a notice back in April, but did you?
Yes, sir. I just said I moved out of the house, so all my stuff is in storage. I thought I had the paperwork on me, Your Honor, but I did call Thursday and got the information. The young lady down there gave me the wrong information because I most definitely logged in at 10 before 10 o'clock, but it was the wrong one.
All right, so I mean, any information you would have gotten from anybody else, and that's the reason why we send the written notice out to you, so that you don't have to call in, because you might get the wrong information. But that's on you, because once you get a notice from the court, if you store everything, you don't store your court date, you got a court date coming up, because that causes you to get in a situation like you're in right now. So what I'm going to do, ma'am, is I'm going to reset. I'm going to reset the hearing on your matter because of the explanation that you've given me. So let me give you another date to come back now.
Okay.
In here, so,
When you want to bring it?
yeah. August 4th is going to be the date you come back, ma'am. August the 4th, and that's going to be at 9:30. I'm going to notify the other side so that we can pull everybody together in regard to this matter. August the 4th.
Okay, thank you, Your Honor.
All right, thank you.
Have a good day.
And you said you have a new address. What's the Can you put the new address in the chat, ma'am?
139
Uh-huh.
06 Arlington, Arlington Street, Hamtramck, Michigan, 48212.
All right, 13906 Arlington Street in Hamtramck, 48212.
Yes, Your Honor.
All right, thank you, ma'am. We'll get the notice out to you.
Okay, thank you.
All right, thank you for that. Reed versus Overs.
Oh, I think you still have. And in 827.
Yeah, that's it. They need to change the address.
Okay.
I put